Hello, friends of the Dick Show podcast. I am Nicholas Rekieta, your resident attorney, and I am here to have a brief encounter with a certain lawsuit filed by Maddox and served upon Dick Masterson. You all by now have probably read this, but I'm going to go through and give you my learned legal opinion, which is pretentious and everything. So I'm going to do that with this bottle of Balmore Scotch, which is fantastic. And we're going to see how this goes. So just bear with me. Full disclosure, I have skimmed part of this lawsuit. I haven't read the whole thing in detail, hoping to get some genuine reactions and some good laughs out of it. So here we go. There are 53 pages. Some of them will hopefully be brief. The first page is just a summons, and the only notable thing of interest is that Maddox has himself and a Jane Doe listed as plaintiff. And then he has listed, of course, Dax, Foundation Digital, which is Dax's company, if you don't know. Greg Bozer and Lauren Baker, who are both affiliated with Dax. CMGRP Inc., doing business as Weber Shandwick, which is the employer of Asterios. Joshua Kaufman, who I think is the actual attorney of Weber Shandwick. I don't even know. Trevor Burt, that's your buddy Tab, also known as Maddox. Patreon Incorporated, and Jordan Cope. So, okay, we'll see how that works out for him. This is a lawsuit brought by Kevin Landau, and he has a nice New York address, which I'm sure you can all laugh at. Kevin Landau is licensed in both the state of Michigan and the state of New York, and his firm, the Landau Group, which is a 3-attorney firm, says that they handle all sorts of different things, notably dog bites in Michigan. So, best of luck. Dick, you are biting like a dog. There's probably a joke in there, but it's not funny. So I'm going to move on. I'm going to bore you guys, and I'm actually going to read some of this, so bear with me. Plaintiffs Maddox and Jane Doe, collectively plaintiffs from here on out, by and through their undersigned attorneys, the Landau Group, and as and for their complaint against defendants Dax Herrera and all the other people, allege as follows. Plaintiff George Uzunian is a writer, an internet personality residing in or around Los Angeles, California, conducting business in New York. I did not know that Maddox specifically conducts business in New York, but we'll see. Plaintiff Jane Doe is an individual residing in or around Los Angeles, California. Plaintiff Jane Doe and Plaintiff Uzuzian were in a relationship at most times alleged in the complaint, and she is referred to as Plaintiff Uzuzian's girlfriend in this complaint. It's important to note that while it is funny that she potentially has broken up with Maddox in the interim, they were not in a relationship when the biggest problem started, which is where the complaint starts in a few moments. So this doesn't necessarily mean they're broken up, as funny as that would be. Laughing at other people's pain is one of my hobbies. Defendant Dax Herrera is an individual residing in or around Los Angeles, California. Notice a trend with these addresses. Conducting business in New York. Dax, what business do you conduct in New York specifically? Herrera is the vice president of technology and the co-founder of Defendant Foundation Digital LLC, a search engine optimization and marketing company, conducting business in New York with clients such as Asbra, ESPN, and Disney. How dare they? Defendant Greg Bozer is the president and co-founder of Foundation Digital, conducting business in New York. Does Greg Bozer conduct business in New York? Defendant Bozer has promoted and appeared on Herrera's podcast, The Dick Show. Defendant Lauren Baker is a co-founder and vice president of business development for Foundation Digital, conducting business in New York. Again, does Lauren Baker specifically conduct business in New York? Baker has also promoted and appeared on Herrera's podcast and has solicited funds for Herrera's podcast on his Facebook page. Defendant CMGRP Inc., doing business as Weber Shandwick, is an international public relations company with its headquarters in New York, New York. Oh, finally, someone actually in New York. Defendant Asterios Kokonos, cock in nose, is a senior copywriter at Weber Shandwick residing in and conducting business in New York, New York. Good job, Asterios. Defendant Trevor Burt, defendant or Burt, I'll have to pick one, dummy, is an individual residing in Oklahoma, conducting business in New York, New York. Tab. Stop conducting business in New York. This is serious. Defendant Patreon Inc. Is a Delaware corporation conducting business in New York, New York. Defendant Jordan Cope is a creator relations lead at Patreon conducting business in New York, New York. Good job, Jordan Cope. The court has jurisdiction over the defendants in this action pursuant to CPLR 301 and CPLR 302. Venue is proper in this court pursuant to CPLR 503. That is up for debate. Venue does not appear to be proper in this court at all. So I haven't read 301 and 302, but these are probably New York's long-arm statutes, which allow them to have jurisdiction over someone with something called significant business contacts. I won't bore you with a civil litigation class here on the rules of civil procedure, but long and short is each state has a statute which allows them to exercise jurisdiction over someone with significant business contacts in a state. I bet none of these people outside of the companies themselves have anything close to significant business contacts. There are a litany of cases that really cast doubt on the idea that simply because something may have reached a state, for example, a podcast may have been listened to in New York, that a significant business dealing has occurred in New York with that podcast. So the mere dissemination of material into a state, unless it's targeted, doesn't provide the necessary contacts under the long-arm statute. So already this lawsuit has massive problems. Most of the defendants can simply state that they do not fall under this court as a primary point of their argument, and the venue is improper and the court doesn't have jurisdiction over them. So that's the first issue. Good job. I'm going to hold on a second. I'm going to try not to, but I'll probably drink every time something is blatantly retarded. And we'll see if I just die by the end of this. So, in 2014, this is a statement of facts, by the way. Facts. These are facts. Plaintiff Uzunian launched a podcast with defendant Herrera entitled The Biggest Problem in the Universe. Prior to said podcast, Plaintiff Uzunian was a highly successful author. Highly successful with one solid book sale and then one not so solid book sale. An internet personality, and his book entitled The Alphabet at Manliness achieved number 2 on the New York Times bestseller list. Good job. That was a funny book, Maddox. I'll give you props for that. In 1997, Maddox developed the website The Best Page in the Universe, and by 2014, Plaintiff's YouTube videos have been viewed by millions of people, including hundreds of thousands of subscribers. And why the hell didn't you just keep that up, you idiot? Plaintiff Maddox, I'm going to stop trying to pronounce his ridiculously Armenian name, because I don't have time for that. Brought his fan base, money, and resources to the aforementioned podcast. Money. Lots of money. And requested defendant Herrera to participate in it. In 2014, defendant Herrera was relatively unknown, had a small fan base, few resources. He had the steady job, though. That's good. And therefore, being included in plaintiff's podcast represented a huge opportunity for him. Big opportunity there, Dick. The podcast became one of the most successful on the internet and ran for over 2 years. It ended on or about May 13th, 2016, which established Maddox and Dick's business relationship and association, or so Maddox had thought. Dun, dun, dun. Just in case you needed a dramatic cliffhanger, in number 17 of like 120 points here, you have one. What happens next? Subsequent to the podcast ending, Dick, in conjunction with the other individual defendants named herein, created cyber mob attacks. Watch out. And numerous online harassment campaigns. Dick, serious question. If you were creating these cyber mob attacks and online harassment campaigns, where the hell was I? I was not informed, and I would have liked to participate. I'm offended. against Maddox and his girlfriend, Metal Jess. That has endured until the present. There are still harassment campaigns and there are still cyber mob attacks? You bastard. I want in. The harassment campaigns Dick and other defendants have created and continue to create against plaintiffs are appalling, wanton, vindictive, ruthless, and patently repulsive. They're not latently repulsive, y'all. They're patently repulsive. That means they're repulsive in the front, not in the back. You don't find out they're repulsive later. What's even more nauseating is that defendant Herrera, in conjunction with the other defendants, have created a thriving business based around their continued harassment campaigns, cyber mob attacks, and threats against plaintiffs. Yes, the entire Dick Show podcast and everything that Asterios and Tabbert and Foundation Digital and Weber Shandwick and Patreon themselves all do is centered around harassing Maddox. Defendants... Oh, wait. That earns a drink. I cannot express enough the value of a good scotch. Defendants' targeted campaigns and business model uses many forms of social media, technology, and platforms on a variety of mediums, which plaintiffs explain more fully below. Ooh, the suspense is killing me. All right, now he moves on to Dick specifically and the Dick Show, which, mind you, he has not sued the Dick Show podcast. He has just sued Dax Herrera and his persona as Dick Masterson. I don't know how Dax has the Dick Show organized. If he were me, it would be done as an LLC, specifically owning the show, and therefore Dick would be protected from liability against pretty much any of this. I assume you've done that, Dax, but if you haven't, maybe it's a good time to consider. Even though this is probably retarded, and you don't have to worry about it, there could be something in the future. So talk to your attorney, Keon or whatever. The show, which is distributed through Patreon. Presently, the show has 3228 patrons, paying defendant Herrera $19,673 to over $22,000 per month. So they're paying a nebulous amount. I wonder what Maddox's Patreon numbers are. The show is also linked to defendant Herrera's YouTube station. It's a channel. It's a channel. And other social media, such as Facebook and Twitter. Well, Dax, is it linked to your Twitter? I thought you had issues there. Patreon is an online platform that allows individuals to set up a web page for their creations. The creator of the page can charge each patron a fee or pledge to access said creation. This is really boring. Their patrons may pay additional fees to access other content. Okay, we get this. This is pointless. Defendant Herrera, with the other defendants herein, have used the Dick Masterson persona across social media and the internet. Okay, so the other people have used the Dick Masterson persona. So that's interesting. Across social media and the internet, which is described as Twitter, Facebook, YouTube, and iTunes. That's the internet. To create a lucrative business based on creating violent and hateful content directed at and against plaintiffs. Plaintiffs apostrophe? Okay. Grammar, buddy. Thereby encouraging and inciting their listeners and followers to threaten, stalk, harass, defame, and interfere with all aspects of their personal and professional lives. All aspects. For instance, one of Maddox's major sponsors on his network was from a company called Harry's. Maddox, buddy, maybe you shouldn't have affiliated with such an idiot on your network, your podcasting network. Very novel concept. Good job. Notice how, that's not really a thing. But, so your podcasting network has someone who's willing to call an African-American the N-word on live air. Good job. Harry's is an online business that sells razors and other men's shaving products. Defendant Herrera created a harassment campaign to destroy plaintiff's relationship with the company. Pretty sure that wasn't Herrera at all. Wasn't that Joel Chaco? And Stove? Angry stove? Okay. Sorry. I didn't know Dick had anything to do with that. Herrera encouraged his fans to troll through plaintiff's network looking for clips to take out of context. Who's done that before, Maddox? Herrera, then in coordination with his fans and other defendants herein, spammed Harry's social media sites. They don't define spammed, which is funny because I can only imagine like a New York City judge sitting there being like, what the fuck is spammed? Like, is that a can? Meat? Are they throwing meat? With defamatory and outrageous accusations. George, Maddox, buddy, defamation is only defamation if it's not true. Everything sent to Harry's was true. Someone on your network dropped the M-bomb on live air, and last I checked, we live in an age where that's not okay. Whether you agree or not, people are getting crucified for this, you dummy. Defendant Dick willfully and maliciously encouraged his fans to contact Maddox's sponsors on his podcast and even justified this harassment. Justified. Further, Herrera posted about it on his Facebook page, calling Maddox a liar. Well, only defamation if it's not true, you liar. And incited his fans by explaining that more hot goss would be coming. What is hot goss? You don't define that, you dummy. This is a judge. A judge doesn't listen to the Dick Show, probably. If he does, you're already fucked. As a result of the foregoing, Harry's canceled its sponsorship. This decision by Harry's was based on the targeted harassment campaign. Actually, I'm pretty sure it's based on the fact that your new podcast gets dick for viewership. Directed by defendant Herrera against plaintiff, which Harry stated to plaintiff as follows. The social media response we've received from trying to sponsor the show bears a cost. As such, our brand isn't comfortable taking a risk here. They're not comfortable paying you, you dummy. If this is, in fact, a targeted harassment campaign, that's disappointing and frustrating, and we hope that they're able to get it resolved as soon as possible. You see, this is, you established Harry's as a business contributor under the biggest problem. And then you got a bunch of people to buy into Harry's, and then you jilted something like 70% of your fans by being a cunt. So Harry's left because their fans no longer like that they sponsor you, because they're not there for you anymore. They really probably weren't. By the time Harry's joined the biggest problem, you were already an idiot. Prior to defendant Dick's campaign, Harry's was one of plaintiff's largest and longest sponsors. Plaintiff's deal with Harry's was $45 cost per 1,000 impressions, which means that Harry's would pay plaintiff $45 for every 1,000 downloads. Well, Harry's is fucking stupid. At the time of Herrera's harassment campaign, plaintiff was averaging 30,000 to 40,000 downloads per week, based on 40,000 downloads per week, even though, okay, whatever. Maddox lost revenue on a given week from Harry's roughly equals $1,800. Ouch! Why was Harry's paying your dumbass $1,800 a week? That's why they cancel, you idiot. Monthly totals would roughly equal $7,200. One of plaintiff's other primary sponsors, Kendall and Hyde, good representatives there, a leather goods store. They didn't sell leather goods, they sold lies, you idiot. Was targeted by defendant Herrera's wrath for months. Herrera directed his fans to harass Kendall and Hyde in targeted harassment campaigns, whereby he directed his fans to flood Kendall and Hyde's social media, attacking the company for supporting Maddox. Defendant Herrera's fans made numerous posts and tweets. One down, buddy. By the way, if you're in Minnesota, Rekieta Law, justice. It's like revenge, only better. Let's see. So, whereby he directed his fans to flood Kendall and Hyde's social media, attacking the company for supporting Maddox. Defendant Herrera's fans made numerous posts and tweets. You're not suing the fans of Defendant Herrera. You're not. You're suing Defendant Herrera. So what did he do? indicating that plaintiff supported and advocated for rape. How does that feel? And that Kindle and Hyde was therefore sponsoring and supporting a person that advocated and supported rape. Herrera personally targeted Kendall and Hyde as well. Oh, here we go. Here's a tweet. Maddox, when you're writing a lawsuit, and your lawyer, who I'm sure is great, when you're writing a lawsuit, you don't include the evidence in line in your complaint. You include it as an appendix attached later. Therefore, you can easily reference it by exhibit. So this would be Exhibit A, your first piece of evidence. And then the next one would be Exhibit B. Or you could go with a numbering scheme. That works as well. It depends on how many exhibits you have and what the court likes. But you don't put it in line because it's just stupid and unprofessional. Dick's tweet. In the new alphabet of manliness, C stands for cringe. Brought to you by Kindle and Hyde. Yeah, you advocated groping in Alphabet of Manliness. Which, by the way, good book. I really enjoy it. Still funny, even though you're not. Defendant Herrera incited and encouraged other harassment campaigns. Okay. Let me see if New York... I apologize. I've got to check. New York statutes incitement. Incitement. There isn't a New York statute for incitement. So, like, inciting someone to harass would be covered under the harassment statute. And because of your network idiot, Jesse piece of shit, I actually know it's Article 120. Oh, come on. Let's see. Let me see if I can pull this up here. Apparently the New York statutes page is down. Let's see if I can pull this up real quick. Sorry. Yup, it's down. Okay, well, I'll just pull it up because I actually have it on a document against your dumb podcast, buddy. So, New York Penal Code 120.45. This is a harassment statute for stalking and harassment. So, a person is guilty of stalking in the fourth degree when he or she intentionally and for no legitimate purpose engages in a course of conduct directed at a specific person and knows or reasonably should know that such conduct, one, is likely to cause reasonable fear of material harm to the person's health, safety, or property of such person, member of such person's immediate family or a third party, or cause material harm to the mental or emotional health of such person, where such conduct consists of the following: telephoning, initiating communication or contact with such person, a member, blah, 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 or is likely to cause such fear. Interestingly enough, the New York statute on harassment and stalking doesn't actually seem to have a third-party liability, that's honestly a little surprising for me. I would guess that they would incorporate this. I haven't researched it. I'm sorry. I'm not a New York lawyer, so I don't waste my time on that too much. But yeah, the idea that Dick is incitement is a crime, and incitement has typically a specific statute. So you can't just claim that he's inciting something. Encouraging others to harass isn't the same as having a third party act on your behalf, which is typically what happens in a harassment case. But good job. I hope you enjoyed paying that retainer to your lawyer. It wasn't worth it. Defendant Herrera incited and encouraged other harassment campaigns. At this rate, I'm going to be fucking hammered. In one such campaign, defendant Herrera's followers used one of the plaintiff's sponsors' Candid, a social messaging app. Okay, let's get some syntax here. In one such campaign, Dick's followers used one of the plaintiff's sponsors' Candid, a social messaging app, period. This unconscionable and repulsive campaign was not only directed at Candid, but at plaintiff's girlfriend and plaintiff Jane Doe. At plaintiff's girlfriend and plaintiff Jane Doe? Isn't that the same person? Whereby defendant Herrera's fans threatened and discussed raping plaintiff Jane Doe's, and that this was common topic for discussion on Herrera's fan page. You have to produce evidence that it was common discussion. And even so, this doesn't implicate Dick in any way because he didn't advocate the rape campaign against your fake girlfriend. By the way, if anyone doesn't know, Metal Jess is fake. Pretty sure she's not a real person. Nice bags of sand there, Maddox. I won't read through these rape threats on Candid. Candid is a free speech app, you moron. Like, that's the whole point. They remove the names of people involved, and it's a private forum where you can say anything, and they simply get around this, the ability to say anything, which is, it should be there anyway. But they remove the names, and then they remove offensive content from people who don't want to see it, which allows anyone to say whatever the hell they want because their offensive words won't reach your sensitive girly ears. Sorry, ladies, that was rude. Plaintiff Jane Doe has been a target and focus of defendant Herrera and defendants Kokonos and their fans for several months. No, actually, she hasn't. She preemptively blocked pretty much everyone from Twitter, if you'll remember. Defendants' followers frequently levied racial slurs, consistently threatened to rape. They actually didn't. Saying get raped is not the same as saying I am going to rape you. That's a different thing. And kill plaintiff Jane Doe. And invaded her social media accounts, business associates, friends, and disrupted her entire life. Well, you play with fire. To the point of causing her to seek therapy. Good job. Good job, Metal Jess. You probably need it outside of this anyway. You are dating a moron. As a consequence of living in perpetual fear and dismay. The foregoing vitriol against plaintiff Jane Doe. Vitriol is not illegal, Maddox. You're a fucking cunt. That was vitriolic. It's not illegal for me to say you fucking cunt. Let's see. It has been at the behest of defendants. Prove that. You haven't proved that. This should be easy to find evidence of the defendant communicating with a specific group of people what to do, and you haven't done it yet. I assume it's coming. With their enthusiastic encouragement. In addition to the foregoing, cite a podcast minute, you dummy. In addition to the foregoing images above. Foregoing and above is redundant. Go to fucking grammar school. Below is some of the other vile and racist rape and death threats that Jane Doe has been forced to encounter. She's not forced to encounter anything. Block them. She already blocks people. From all over the country. Notice it doesn't say in New York specifically, which is a critical point of your lawsuit, you moron. They have to be in New York committing this act. And you haven't shown that. And you can't because you're stupid. Sorry. Getting drunk. In which defendants have encouraged of their followers as part of the show. Cite to the minute or the episode even. But you don't. There's some pictures of some bullshit. You will die for what you did, you nigger. Well, that's rude. That's what... that was apparently a post by Jessica Alex Worm. Here's the thing, though. That's an offensive comment. And probably shouldn't be said in polite company. But it's not a death threat. You will die is not a threat of I will kill you. There are very different things happening here. And it's true. She will die. For what you did is likely true as well. Even if she gets cancer, that's likely a result of her decisions. So, anyway, I'm sorry. I'm digressing. I gotta move through this faster. However, what is truly disgusting is that all the foregoing venom states that from stems, too much scotch, stems from the defendant's direction and represents the central principle of their business model. The central principle of their business model is to create content targeted at destroying Maddox's life and those associated with him. Actually, if you look, it's a science and rage-based podcast. Pretty clearly that their central business model is not you. And the fact that you're barely mentioned, almost to the detriment of the podcast, I mean, Dick should send you a thank you note for this, by the way. He's insured content for months to come. You fucking moron. Below, this is item number 33. I'm so unprofessional, I apologize. Below is an example of Defendant Herrera's ruthlessness and his misappropriation of plaintiff Jane Doe's image and likeness for his own financial and perverse gain. So, Dick is replying to the tweet of another person, which includes Mental Jess's image. Importantly, Dick Masterson did not post the image. You idiot. He has to do it to use her likeness in an improper way. He has to use her likeness. He simply comments, is that an invisible horse cock she's sucking? And it might be. We don't know. We can't know. We're not her. Below are examples of defendants' extortion and criminal harassment. I just read you the criminal harassment statute. Of plaintiff's family, friends, family, and colleagues. Here we go. I'm going to zoom in on this because this is important. This is criminal. Now, remind you that criminal harassment is a statute that must be proved beyond a reasonable doubt by a jury of your peers. You can't just claim something's criminal. That's conclusory. There's a statute. There's a case. Sorry, getting drunk. There's a case about this. It's Iqbal. My lawyer homies will know this from their civil procedure class. Iqbal, IQBAL. IQBAL? I don't even know. I don't spell Muslim. Iqbal is the most recent case on this, and you have to you can't make a conclusory legal statement. You have to state facts and allegations which lead to the conclusion of a statement, but you can't say something is illegal without it being proven illegal, or at least offer the substantial proof. So if you have a court order saying this is illegal, like say Dick is ticketed in New York with a misdemeanor for his illegal harassment, for example, then you can say it's illegal. But without that ticket, you can't call it illegal. You dummy. You can get your lawsuit dismissed for this, you moron. So here's Dick's tweet. It says, leaving with the ex. That's true. Hit up Brian. That's not intimidating or harassing or doxing friends who are non-public figures. That has nothing to do with it. I have no idea who Brian is. You blocked out the name. Even if it's a last name, that's not the doxing of a public figure. Like, that's a colloquial use of doxing that we use on Facebook groups. It's not the legal definition of releasing information that allows the identification or location of a person. I'm not going to get into this too much because it's federal law and it's really undeveloped because the internet moves faster than the 9 idiots on the Supreme Court. But you can't just say that doxing is a crime. Like, revealing personal information that would give people like an address or a location or something might be illegal without their consent. Might. But you can't just say that naming someone online outside of any context and without any other identifying information. Like, I can just type names into Twitter all day. That's not illegal, you dummy. So your next one is blackmail with threat of revealing private, intimate details of my friend and colleague at Leah whoever. Dick tweets, I saw Leah deleted her mean comments about me, but she didn't issue a retraction. So, Goss? ? That's not a threat or blackmail, you moron. Blackmail would maybe... Blackmail... It tends to entail the payment of money to do something illegal or to violate someone else's rights. Like him saying, even if Dick had come out and said, Leah, delete your comments or I'm going to talk about you on my podcast and reveal negative information about you, that's not blackmail, you moron. Jesus Christ. Whew. Sorry. Item number 35. I'm not moving through these very fast, and I'm not going to go through all of these. These are stupid. Numerous examples of Herrera's defamation. Defamation is a legal conclusion, you moron. Vitriol is not illegal, and incitement has a very specific legal definition of his fans and patrons to target and harass plaintiffs exist. Plaintiffs exist. Numerous examples exist. Oh, okay, sorry. That's me, not them. Specific examples are indicated by the red arrows below. I encourage you to read this because these examples, 1, 2, 3, 4, 5, 6, 7, 8, 9, none of them are vitriolic or are defamatory or incitement under the law. Not a single goddamn one of them. So, 36. Defendants have also created Wikia pages. Did Dick, Asterios, Maddox, or their respective employers or Patreon create the Wikia pages? Because if they didn't, and if you can't prove it, which you provide no evidence for, then they didn't create them, you moron. They've created Wikia pages and a page on Encyclopedia Dramatica directed at plaintiffs. This is likely done by the fans, by the way. Likely done by literally anyone who listened to you turn into a giant vagina. And they're filled with false allegations of sexually transmitted diseases, mental problems, homophobic, whew, I'm going to drink to myself there. I was an idiot, can't pronounce anything. And racist slurs, not illegal. And a false story of the plaintiff's lives. By the way, also not illegal at all. Although some of these pages have been taken down by Wikia, a current Wikia page is up entitled The Dick Show Wiki, which features an intentionally dishonest portrayal of plaintiffs inclusive of photographs used without their permission. This isn't illegal. I can post your picture anywhere I want. You're referencing... I got it. Full disclosure, in skimming this, I found out their ultimate claim is under the New York statute for use of images or namesakes or likenesses without permission in a commercial endeavor. A Wikia page is not a commercial endeavor. It's not an advertisement. So I can post nudes of you on the Wikia page without your permission, you dummy. That's legal. God, you're fucking stupid. Your lawyer's stupid too. What is he doing? Although some of these pages have been taken down by Wikia, a current Wikia page is up entitled The Dick Show Wiki, which features an intentionally dishonest portrayal of plaintiffs inclusive of photographs used without their permission. I read this. Similar to the Wiki page, an Encyclopedia Dramatica site was created for the same purpose and remains available for public consumption. Hold on, I want to see something here. Bear with me. I'm very unprofessional. Whew, I can barely spell right now. Let's see. Encyclopedia Dramatica. Page information. Holy shit, that didn't do any good. Whoa! I don't want to do that. God damn it. Okay. So...
Critical alert from Microsoft.
Holy shit.
Your computer has alerted us that it is infected by a virus and/or spyware. This virus may be sending your credit card details. Critical alert from Microsoft.
God damn it.